I myself have a state-issued medical license from the Pennsylvania State Board of Medicine. So that is, my background is in pulmonary medicine, and I'm still trying to share my screen with everybody, so just give me a few minutes. But like I said, I have medical background in pulmonary medicine. Jody is a nurse practitioner and has a doctorate in nursing as well. And all of the other medical specialists that we have on board all have medical licensing in some field or another. So they're all state board certified by a medical professional in some capacity. And that's worked out well because there have been issues that have come up, and there have been other issues as far as and questions that have arisen there, but we'll get into those as we go through this a little bit. And I cannot mute all.
Ray Cappuccio, can you mute your phone?
There we go. I was trying to find out who it was, but there's 200 and some participants. But anyway, I will probably stop sharing my video here so that we can, so that you can kind of get a hold of this a little bit better. But everybody should be able to hear me. If you can't see me, that's all right. As long as you can see the video or the presentation, we're okay. So we're going to go ahead and get started through this. What we're basically going to be talking about today are some of the things that we have in Boyer's Disability that, wow, some of the things in Boyer's Disability that that hold up our cases, and some of the things that the agencies can help us with. Some of the basic things: healthy case submission, agency-related forms, things that you're supposed to be completing and sending to OPM. Some of the common errors and discrepancies that we see on these forms. Removal for medical inability, which is a hot topic, especially in our capacity. And if we can get to it, we'll do some reasonable accommodation and reassignment, and then we'll do some question and answer at the end. Now, we're gonna go ahead and go through all of these here: basic eligibility and entitlement, just the very basics. What's going on here? Healthy case submission, agency-related forms and their completion, common errors and discrepancies, and I actually have examples. Now, obviously, the names and things that I'm going to have up here have been changed, but I will tell you that I actually pulled these examples off of some of the forms that have been submitted to OPM, and I am literally not kidding you. When you read the one, you're gonna say, "There's no way that was put on a form." I guarantee you it was put on a form. You'll understand when we get there. And then we're going to talk about removal for medical inability, and if we can get to a reasonable accommodation and reassignment. So basic eligibility. So we have SIRS and we have FIRS. We all know the difference between the two. SIRS cases, there are still some SIRS cases out there. I still see SIRS cases. I actually just had one the other day in reconsideration, and I couldn't believe the person was still working at 78 years old, bless their heart. But they applied for disability, and they were still one of the old SIRS cases. So for SIRS eligibility, it's 5 years of credible civilian service, and for FIRS, it's 18 months of credible civilian service. Then they must, while in a position subject to SIRS or FIRS, become disabled from a medical condition which resulted in a service deficiency for performance, attendance, or conduct. Now, we say the service deficiencies are very important. Documentation of such is very important, and we'll get to those a little bit later as well. But I just want to show you what the basics are that we're looking for when we get a case. So once we determine that the medical condition is disabling, some documentation must say that that disability is expected to remain disabling for at least a year from the date the application was filed. So not from the date they're claiming, not from the day they went and leave without pay, any of that kind of stuff, but from the date that they filed their disability application. And that's a common mistake that we hear a lot, is that, well, I claimed back in 2017 I was disabled. Well, that's great, but eligibility says you have to be a year from the date of filing. So it's remained disabling, and you can't perform any kind of work whatsoever within your essential duties. So accommodation, we'll get into this a little bit later on too, and the regulation, what it says about accommodation and reassignment. But if they're accommodated, the applicant has to show that that accommodation or reassignment was unreasonable, and documentation has got to be provided by them and the agency. The employing agency must also consider them for reassignment to any vacant position if they filed for a disability. They take priority, and that is covered. We'll cover that again here in a few minutes, but that is actually covered under the SERS and FERS handbook, under the CFR 5 Federal Code of Regulations, and also the U.S. Title Code of Regulations as well. And it's very, very clear in all of those, and judges are really kind of stringent upon some of those. And then if they're separated from service, the application, they must have filed that application within a year from their separation date. Now, the exception there is if they were mentally incompetent to file, and that's the only reason that time period can be waived. And in that instance, there's a lot of hoops and bells and whistles that have to be rung and things they have to go through in order to prove that. So that all is handled on our end. But on your end as HR representatives and agencies, you can also inform them, hey, you separated from here, 5 years ago. OPM is probably going to dismiss your application because you didn't file within the time period allowed within that first year. And a lot of what they're going to say is, well, you guys never told me that. Well, unfortunately, ignorance of the law is not an excuse for not knowing the law. So the merit board judges are not really hearing that argument either. So really the only waiver of that last one there, the 1 year, is, if they're mentally incompetent and we're unable to file within that year. So along with their forms, this one on the left side of your screen here that is what is called the 3112E, and that's the checklist. That should be coming in with every single case that we get. Whenever somebody files their claim, this should have been completed by the agency, and this should have been sent in to OPM, obviously completed. Now, I'll zoom in here and see if you can see a couple of the things, and we'll try to highlight some things as well. Oh, well, it won't let me do both at the same time. All right, so I'll highlight and then we'll go through. So here are the big ones. There are the application for disability retirement. I'll highlight all these and then we'll move in and talk a little bit more about them so you can kind of see the main area that we're looking at here. All right. So you can see here, this is the main body of what we're looking for when they're going to send in an application. One, they have to have that application for immediate retirement. That can be filled out by them. That can be filled out by the agency. That can be filled out by pretty much anybody, but it does need to bear a signature and a date. Then they have their 3112A. That is their applicant's statement of disability. So what conditions are you disabled from? And what other actions have happened? Have you fallen at work? Have you been accommodated? When did you say you were injured and could no longer perform the essential functions of your duties? Those kind of things. And that is most commonly filled out by the applicant. Now, there are occasions where that can be filled out by the agency, and those are special rules. If you have one of those, I would suggest you contact us and we'll help you through that. But for the most part, that's going to be filled out by the applicant themselves. Now, here's where the agency stuff comes in. And these I'll show you the examples of a little bit later, and that's this 3112B. And that is the supervisor statement. That would be from the immediate supervisor, the person that actually observed their work on a daily basis. So we would typically want that first line supervisor, one that, like I said, sees them every day. Second line supervisor is okay. HR agent here and there. And I'll show you and tell you why later on we have issues there with the actual HR agents filling out the B form. but we'll get into that here a little bit later. Performance standards. These are an absolute must. We cannot make a determination in disability that they are disabled from a position that we don't even know the description of the position or what's required of it. So we do have a site that we can go to that tells us a basic description of the job, but it doesn't really give us all of the requirements, physical and mental, just kind of a basic overview. So we're trying to work out a way that we can better communicate, with the agencies themselves and get an actual position description that was handed to the applicant when they took the position. And so far we've been sort of successful and sort of not, but we're working to better do that, and their performance standards and position description. So we'll see these forms here in a minute, but when there's a performance issue, supporting documentation for that is necessary for us to actually see what the deficiency was and determine that if they have that deficiency, how would that have a relationship with their medical condition? So if their performance deficiency is they can't type, well, if they have a broken foot and that's what they're claiming as disability, obviously a broken foot has nothing to do with your typing abilities on a general, reasonable circumstance. I mean, now there are other things that you do or don't have that might be a difference, but I mean, and that's a far-fetched example, but that's kind of why that's required, that we have some kind of a documentation of what the deficiency was, and how it's supported from the agency. Now for the leave use, there's a spot on the form as well that will show you that, where you can put down what they've used, what type of leave it was, and that's important, especially in the case where there would be an attendance deficiency. And again, referencing back to the eligibility, there has to be a service deficiency documented. If there's not, then there has to be proof that they are incompatible with being able to provide useful and efficient service. And I've rarely seen that anybody has actually been able to prove that in the absence of a deficiency, but it is possible. But for attendance, we need those leave records. We need to know dates, kind of what was going on there, and same with conduct. Now conduct, when we're looking at conduct, we're looking at anything that isn't performance or attendance related. And we get this a lot with our forms where people will put, they'll indicate conduct. They'll put a date on there and they'll say, because they failed to show up for work. Well, that's more of an attendance issue than it is a conduct issue. Conduct is if they came in and whipped their computer across the room at their supervisor, or got into an altercation at work causing a suspension for a period of time. Those are more so what we're looking for as far as a conduct issue would go. So that there is a little bit more detail, I think, that we needed on that, but just to prove a point, we really need the documentation. Now the 3112C physician statement, that's just a form that goes along with it, with the application, that goes out to the physician and asks them a series of questions about the applicant and their medical condition, and then asks for supporting documentation. So that's not really agency related, but if the package is submitted to the agency, which they can do, it would be wise to have that within the package itself. So then we move on to the next agency form, which is the D. Now, myself, when I look at a case, I look at the B and D as the B is what the supervisor is saying they were able to provide as far as accommodation efforts go, or to the best of their knowledge, what they knew. And then the D kind of certifies whether those worked or not. And as we get into the forms and you see them a little bit, we'll discuss this a little bit more, but these need to be as accurate as they can possibly be. Now, I do understand that there are agencies out there that have their own separate accommodation and reassignment branch that will actually do that for the agency. And that's wonderful. I'm totally good with that, as long as the documentation is there to support whatever's being said on that form. And if that form is filled out by somebody over there in accommodation, then it needs signed and dated by that person to relieve the HR person of their, of their responsibility. Because I'm seeing a lot more with MSPB cases on review. They're saying, well, this form was signed by this person, but they stated it was from the accommodation department. So the actual person that did the review of the accommodation didn't even sign the form. Or I've seen vice versa, where they've called that person in to testify in the merit board case, and the information that the lady provided in the last one we were at was phenomenal. She had, all her I's dotted and T's crossed. It was really, really good. So the more accurate that is, and the more documentation that can be put in there and submitted to OPM, the better the decision is that we can make. And then the more rapidly this process goes through, which we'll talk about processing here in a little bit too. And you can see there after the D, the supporting information. And then this agency, this part F, that's a whole can of worms that I just kind of started researching a little bit today and in the past about like fitness for duty and things of that nature. Certainly if they go out and they get a fitness for duty and they have a doctor that signs off and says, that they're not fit to do any work at all, or they're fit to do light sedentary work or medium work, whatever that might be. If the position description says that it's a light physical requirement job and they can do medium requirement, if you remove them for medical inability, this one's going to come back and bite us in the end, because the medical evidence doesn't support your medical removal. So if you have a fitness for duty that you send them out for, which you can do, please, by all means, submit that with your documentation as well. That is most helpful. Now, we go over to this other one, which is over here. And I can actually provide this one here for everybody. I can email it to you, and you'll have my email at the end of this. We can send it out to the agencies. There's a lot of different things we can do, but this is internally, this is our development form for disability. The 3112A you can see on here. You can see the B is on here, the C, and everything that's needed for these. And you can see SF50, very, very important to know why they claim they leave. I've had a case a year or so back where a lady said she was so disabled that she couldn't do this, that, and the other, and she couldn't even show up to work. And then I see on her SF50, reason given for removal, wants to travel the world. Well, you can travel the world, but you can't walk to your job or drive to your job. I find it hard to believe you're disabled. So, and then position description, medical documents. Now, for medical documents, we're talking here, is there medical in the case file if you have to submit it? But more so, we're talking about, did the agency certify that there were no accommodations or they were removed for medical inability or something along those lines, and provide that documentation to OPM so that we can see why they made that same decision. And that's kind of more so what we're talking about here. So, like I said, I can get this form out to everybody. It is a helpful guide, but in the long run, if you look at it, it's really not much different than the other form here. And I wish I could show them a little bit larger side by side, but I can't because of the way it's formatted. And I do see you, Michelle, asking for a copy. I will make sure everybody gets a copy that needs one, and we'll move on from there. So this is what we would consider over here on this side, a healthy case if everything here is included. And everything, anything that is missing from this checklist, the specialists now have to develop for. We used to have a development team that did this, but they don't do it anymore. We actually are doing it ourselves just because we were having trouble. We weren't getting the information we needed, that kind of stuff. So this form, as it's completed, you can see right down here at the bottom, it says there's no missing forms and nothing's incomplete. It's a healthy case. Ship it. That should come right to disability. So that's kind of why that's pretty important. So moving forward, we have here the healthy case submission stuff. We talked about this a little bit. Here are the forms, and this one here that I highlighted, and this one here, if you can see that, those are the agency forms. They would get a copy of this, but that would be more accurate coming from the agency. And they'll also get a copy of this, which would also be good from the agency as well. Again, the agency might have on their position description, they might have some addendum that are made to the position description. So if their basic position has X, Y, and Z criteria, they can put an addendum on there saying that this is also an additional responsibility, even though it's not listed on the position description. That's why coming from the agency or the HR folks is by far the more, the easier of them to get. And medical documentation, obviously, we talked about that a little bit, and the timely submission. This again is that 1 year. What is their current status? Are they in pay? Are they in leave without pay? Are they off the agency rolls? Are they on the agency rolls? And has the application been submitted within a year of their separation, if they are separated? And there are a lot of cases that are untimely filed. I think right now the going record that we have in Boyer's Disability, since we've been doing it, is 21 years, I think. There was an applicant that was separated 21 years ago and just now filed for disability retirement. I think that was a last year case. So that would have been 20 years untimely. And then they said their agency never told them they could file for disability. And we looked at the bottom of the SF-50 and it said they were counseled on filing for medical disability. So that case pretty well was a sealed deal from there on. And then if you look at that form, let's go back here to this one here a second. If you will look here at the bottom, or where did that go to? You'll see that there are needed for determination things that are highlighted. Those are the absolute critical elements of a disability form. Can we live without an E form, which is the agency's certification that everything is sent? Absolutely. What we can't live without on that E form, though, is the actual address of the agency that it's going to. We don't know every single agency's human resource and benefits center. So if that's where your documentation goes to, we need that address. And that's kind of where we're going to send our letter once a determination's been made, is to that address. So if you start getting something that you're in Cleveland, Ohio, where your agency is, but your home office is in Dallas, Texas, then you're going to have to send that back to us with a good forwarding address so we know where to go to from there.
Hey, Bob, I'm sorry to interrupt you. We're getting an echo.
Yeah.
I'm not sure who's not muted, but we're getting an echo from somebody, and it's making it very difficult for others to hear.
Oh. All right, let me see what I can do.
Okay, the echo seems to be gone, so maybe somebody already corrected it.
Okay. If those have joined late to this, please go ahead and mute your screen, if you would, please. And then we can go ahead and proceed with our presentation and everybody can kind of hear what's going on. So moving on, where are we at? Right here. So on these agency forms, I know I've harped on this a little bit, and a lot of this presentation is going to harp on this because where we get the majority of our wait time is agency related stuff. Now we do get stuff from the applicant themselves that's late, the medical, that kind of stuff, but overall, the general holdup on most cases is agency forms, whether they were separated and they, tried to go back to the agency and have them fill it out. They emailed an old supervisor, something along those lines. There is always something from the agency that we're typically waiting on. And in a presentation I gave last year down in Jacksonville, if anybody was in on that presentation, any part of it, it was a 3-day long thing that we did down there. One of the things that I harped on the biggest with that presentation was what you see right here at the bottom of this screen. And this is probably as good a time as any to bring this up. And that's right here at the bottom where it says mission, service, and stewardship. I heard a lot at that presentation. Well, they're beyond the 31 days. We only have 31 days after their separation to help them with their case. Where that comes from is that comes from the OPM handbook, where it says in there, there's one little stipulation in there that we should wait 31, or we only have the first 31 days after separation, and then after that, they're kind of on their own. Well, hark back here to this mission, service, and stewardship. As I read through OPM's mission preparing for this presentation, and I read through service, and I read through stewardship, I didn't seem to recall anywhere in there where there was a 31-day time limit on stewardship, mission, and service. So having said that, please, these were federal employees. They might not have been the best, but you don't know their situation. You don't know their medical problem. You don't know their medical history. You don't know anything more about them than what they tell you or what you see at work. But they do deserve our undivided attention. And if we can help them beyond the 31 days, then we absolutely have an obligation per the OPM mission, per the OPM service, and per stewardship to help them out. And I'm a huge supporter of stewardship, because I believe that it is our job to take care of these people whenever and as long as we can, regardless of their situation. So throw that rule out the window of the 31 days. If you want to stick to it, God bless you. When your disability application comes to me, I'm gonna remember that 31 days. Now, I'm just kidding. No, seriously. On a serious note, please give them the best help that you can possibly give them. It takes a minute or two to get an answer. It takes a minute or two to fire off an email to John Smith over in such a place, and get a little bit of information. And like what somebody just put on the screen, yeah, we're public servants. And we're servants to the federal workforce. So, let's keep that standard of professionalism and keep that moving forward. So, having said that, we'll get back on track, and I'll get off my soapbox for a minute. But here on bullet point 2, I want to highlight here, and that's not the employee. And the appropriate agency representative is required to fill out the D and the B. This is not something that the employee can fill out and then give to you to sign. This isn't something that the employee can fill out and sign, and so on and so forth. And I say that because we see them all the time. We see, the same signature, or they'll sign the form, they'll sign the B, and I'm like, well, there's no way that the employer filled this form out with your signature on it. So we get a lapse in time there. So if you get a form, make sure if you fill that form out, you're the one that signs that form. And if somebody else signed that form, make sure that person also signed that form, because like I said, those forms and the information and the supporting documentation and all of that stuff can be brought up in court, and you can be asked to come in and testify in that case. So it should be accurate. And if you just say, well, I don't recall, I don't remember, then I have to go back and say, then have we actually done our due diligence, and have we done our service to this person if we couldn't even document whether they got accommodations or reassignment or not, which is a very basic thing to do. So very, very important that we and the agency fill out the appropriate forms and make sure that those are delivered to OPM. And now here, this is the E where we talk about, again, the address. Very, very important that we have the address on there that we should be forwarding any information to, like a decision, questions, comments, that kind of stuff. For the post office, I know they have a main hub in Greensboro, North Carolina, and they tell us to call through them, and we have a little bit of a deal and relationship going on with them. So we can call and get that kind of information from them. But if your head HR benefits and all that is somewhere other than your actual facility, then please let us know what that is. And we do keep track of this stuff. I have a huge spreadsheet with a couple hundred agency addresses on it, and I do update it every single time I get a new address. So if you help us out there, we'll certainly make sure you don't get anything more than what you need or anything less than we need. And then the last part here for sure. All forms must be signed and dated. If they aren't, they're invalid, and this will stall the disability process because we're going to have to find out why it's not signed. It's going to be sent back to the applicant themselves because it's their burden of proof to prove that all of this stuff actually took place, that they actually sent the forms to their agency, that they either would or wouldn't help them out. So it's going to be sent back, and it's going to delay the process. So please just double check. I'm guilty. My boss Jody will tell you, I forgot to sign something the other day and sent it off, and I had to rescind my decision. And it's a process when we don't get this right. So I know it's human error, and we've all done it. But if you could just double check on those, we get them not too frequently, but more often than we should. So there's places where we'll point out here in a little bit where documentation is required to be supplied to OPM. Now, another thing I got at the presentation that I did in Jacksonville was, well, why? And who said so? Well, the forms that are completed that we just talked about here, the 3112B and 3112D, those forms were actually set forth and approved by Congress. So if you need some justification about why you should do it, I'll point out on the form where it says that you must send the documentation, and then you can go ahead and call your congressman or woman and say, well, why did you do that? No, I'm kidding, of course, but that is where this comes from. It's mandated by all the forms and everything that we're asking for, the regulations that we talk about, the CFR. This was all set forth by congressional order. So if it says to supply documentation, we need that documentation as our evidence. Again, otherwise it just stalls the process completely down. All certifications made by the agency, they must be supported by evidence. So if you offer an accommodation or the employee refuses an accommodation, that must be documented. Just saying, hey, I had a phone conversation with them is enough. But it's even better if you've got that in an email or you wrote a note in your PowerPoint or your Excel spreadsheet or any of that kind of stuff, because again, that's going to come up. And I just heard it 2 weeks ago, I think, at the MSPB case I listened in on. The opposing attorney said, well, how do you know that that was actually said on that date? And she said, well, I have a journal entry right here dated such and such, get a copy and everything. And pretty much that kind of silenced the attorney right there out of get-go. So again, document, signature, date. I cannot stress that fact enough. Those three things are so important, especially the documentation and especially the date. E-signatures right now are, we're back and forth on this. We're hearing they're not allowed to be, we aren't allowed to submit electronic signatures, that a wet signature is required. Now, we understand currently with COVID and things of that nature, there's a lot of people teleworking, a lot of the HR people are at home, not in the office as much, so they're electronically signing forms. The reason why this isn't currently holding up in court with the MSPB is I can go on right now to any one of the numerous sites that offers e-signatures, and I can set up an account under just about anybody's name that would make it look like it was that person. So the actual physical wet signature is actually still, as of this moment, required until we get some kind of an update from either MSPB, which is the Merit System Protection Board, some sort of case law that has come about, or some other guidance in accordance with that. So again, if it isn't documented, if it's not signed and it's not dated with a wet signature, it never happened. And this was something that I was told my first day in med school. They sat down and they said, you're going to go through clinicals, you're going to go through this, you're going to go through that. And you can remember a million different terms, you can remember a million procedures, but if it wasn't documented, it wasn't signed, and it wasn't dated, it never happened and it never existed. So please, by all means, make sure this is going on. And I'm sorry, I've got to say that over and over again, but it's again one of those things that comes up quite frequently as we do our reviews of cases. So now we're going to talk about these forms a little bit more. I'm going to try to highlight some things with these forms that kind of are a little bit far-fetched that they seem, but I guarantee you, other than some of the names I've used, I have seen every single one of these that I'm going to talk about, and hundreds more. I literally have a notebook that has probably half of its 50 pages, some sort of information where there was an error between documentation provided by the agency. And I don't say that to make fun of the agencies. I know you guys are busy. I know you guys work extremely hard. But the more that we can point out the errors, the more we can cut down on them. And then the faster this disability process can go along. I don't know if I have it later on in the slides or whether I passed over it, but when Boyers took over and hired all new medical specialists that all had medical licensing, I was the first one actually hired. I was in October of 17 or 16, I can't remember which. But I was the first one hired along with another specialist, Sarah, and Jody. Jody came on. She was hired the same time as us, but came on a little bit later. And when we first started taking these cases, they were 2.5 years behind. So in other words, people that had filed in 2014 and 2015 had been waiting for 2.5 years for a decision on their case that hadn't been done yet. Our current time for initial cases is down to, I think, somewhere around 30 to 40 days. So in just 3 years, actually 3 years this October, we'll have gotten this backlog of cases. It's already caught up, and we are actually adjudicating cases that were submitted in the last month. So that's quite an accomplishment. And I'm not saying that to pat myself on the back, but I'm saying that because what will stall that process are these common errors where we see problems on these forms, and then we have to either develop out to the agency, which is an email or a call, whatever way we have that we can get a hold of them, and we have to send something to the applicant themselves. Then what happens is the applicant gets a hold of their human resources and then barks at the human resources, why didn't you guys fill this out? And so there's just this big long mess that happens, and then that's why we end up getting years behind. Hopefully that never happens, but at least while I'm here, I hope it never happens. I don't think Jody or I will let that happen, but again, you can see how important it is that these forms are filled out correctly, just because I don't know if that was what necessarily caused the backup in DC of 2.5 years, but you could certainly see how if you get 15,000 cases in a year and 50% of them have to be developed, then you've got 50% of those cases that are pushed off to the next quarter, to the next month, whatever it might be. And if that happens year after year after year, you can see how 10 years of that you would be just buried and stuff. So again, accuracy of these is very important. So the errors that we see are the B and the D don't match. And I'll show you what I'm talking about there. And it's more so the certifications of what's going on, what's happening with the applicant. And a lot of this, I think, is just miscommunication either between the supervisor and human resources, or just interagency error maybe that they're just not matching. And like I said, I'll show you what I'm talking about there shortly. The B and the D are opposite. So the agency doesn't know what the supervisor statement noted, or vice versa. And I don't, again, know why this is happening, but you'll see in the examples what I'm talking about when we get there. Then the Form D states things like, see the supervisor statement. And there's one department, and I won't call them out publicly amongst us, but there is one that is notorious for filling out question 4 of the D form and saying, see supervisor statement. Well, that's great, but if the supervisor didn't send me any information or said they weren't accommodated because of a medical condition, and I don't have the medical, then this form is basically, I might as well just throw it away and start over, because it tells me no information that I need to know to be able to adjudicate this case. Like I said, these forms are critical in us making these decisions, because we have criteria that we have to meet in order for a person to be eligible and entitled. So, excuse me, so just having a disabling medical condition is not enough to get FERS benefits. I have had many, many people in my years of doing this that have been disabled, but didn't meet the eligibility or entitlement criteria because they didn't certify that they were applied for accommodation, or they applied for accommodation and the agency gave them everything, single thing they wanted. So you've got to meet these other critical elements, not just being disabled, but some of these other elements. And since we aren't their supervisors here at OPM, and we aren't their agency, we are heavily dependent upon the agencies for information and help as far as some of this stuff goes. So that's why stuff like this here, the supervisor statement doesn't help us any on that form. We have forms that are left blank. So they'll fill out the name, social security number, and leave the form blank. Sometimes the agency will sign it, sometimes they won't. They won't certify anything. And as you'll see on these forms, there are plenty of spaces to type, to write, to put information in there. And we have agencies that will actually submit additional documents. They'll say, see additional documents, and they'll actually attach a statement to that. Here's what happened, here's what was going on, and that is absolutely great. That is helped us accomplish another critical element of what we need to establish. So forms not signed and dated. Again, you can certify everything you want to on that form. You can mark it 10 different ways and twice on Sunday. But if it doesn't have a signature and a date, it never happened. None of what you certified on there, all that work you did, doesn't matter to us because we have no validity for statements that were made. And therefore, we've got no leg to stand on. So then we've got to develop, we've got to make some other kind of arrangements, decisions, that kind of stuff. And mostly we just sick the applicant on you guys. No, I'm just kidding. But again, we have to have that stuff submitted in. And the form's not being submitted. We have that all the time. We don't send in there. I have a case sitting beside me right now. The guy sent in his 3107, which is the applicant's or immediate retirement, and he put in his A and said, I have PTSD. And that's it. Signed that form and sent the whole package in. There's nothing else with it. There's no B, D, E, C, no medical, no nothing. It is literally about 8 pieces of paper is all his cases. And I couldn't believe that we're there. And of course, that's an error all the way around the board because that means somebody in their initial didn't develop. If it's gotten to me, it's being reconsidered. So nothing was really done with that to begin with. So yeah, we all have PTSD, Giselle. I do as well. I'm a combat vet and I have mild PTSD, but I'm not going to freak out on anybody, I promise. Jody, however, does know my contingency plan for disability, and she is well prepared to file my claim for me in the error that I do. So,
And you guys don't know what that is.
Yeah, I won't tell it. It's not public knowledge. So here is a form. Now, granted, I have changed the names on these forms, and it's kind of funny, but it's kind of silly and to a point. But I will say that I have actually had form come in like this, and let me point out here exactly what I'm talking about. Somebody actually wrote on their form, John Jacob Jingleheimer Schmidt. I kid you not. It was done right there. And they didn't put their title down or any of that kind of stuff of their position of record. And so this one really took a lot of doing, but what I'll highlight and then I'll zoom in a little because I'm not sure what all you guys can and can't see on these forms. But this part up here in the upper, this is side 1 of the 3112B, and this is known as the supervisor statement. Okay, so this would have the applicant's name up here, date of birth, their social, all that, what their title was when they were there, when they entered into that position. Now that's critical, that piece of information right there, because the federal regulation covering eligibility and entitlement states that they must have a disabling medical condition. And then when you go into the definition of what a disabling medical condition is, it states in there that they must be disabled from their current position of record. And then we found out through watching and seeing merit system cases that current position of record is defined as that position that was held when the application was forwarded to OPM for review. So if they changed positions in December of 2018 and filed from the old position and it was forwarded to OPM in 2019, then they have not filed from their current position of record, and that'll be sent back. I know that's kind of a hard example to follow, but basically that date on there, that date of entry into the position is important for us to look at because it tells us what position they held, and then we match that date with what their position is that they're certifying that they're disabled from when that application was forwarded to us. So we have to make that determination based off of this. We match that with the IRR and any SF50s or any of that other stuff that was mentioned within there. So let me go ahead and erase right quick and go with something else here. So we got kind of the upper part there. So in this part 4, right here, the first question they're asked is, do they have a deficiency in performance? And you can see here that the application has indicated no. Okay, then, so they don't have any performance deficiencies. They entered their position in 19. Okay, so we're good there. Nope, nothing performance-wise. Then you go down here, has the employee stopped coming to work? Well, nope, they're still working, so they're still here. Okay, then where are we at? Down here, conduct. No, there's no conduct issue. Okay, so then we go down here and we look and say, well, were there any accommodations? And the supervisor here says, because remember, this is the supervisor's form. Supervisor here says, not necessary, they performed all of their duties. So they have no documented service deficiencies. So in this case right here, we would have to prove that they were incompatible with providing useful and efficient service. So right now, everything seems to be on par. They've got no performance deficiencies, they've got no attendance deficiencies, and they've got no conduct, and they're doing everything to the best of their ability. But now let's go over here and let us look at the agency, what they would certify. So the agency over here says, as you can read up here in the top, no, the medical evidence presented to the agency shows that accommodation is not possible due to the condition, or the medical condition and the physical requirements of the position. Now, the supervisor just certified that they were doing their job fully successfully. So in this instance right here, would it be more appropriate to maybe check box 2, where it says, no, the condition doesn't appear to require, or would it be more appropriate to put something in the writing section or the typing section that is allowed down here? And I'll just run a highlighter there so you know what I'm talking about, right in there, and just type something or write something that says, well, we sent it to reasonable accommodation and they determined that that the person couldn't be accommodated. There was nothing we had for them. Totally acceptable answer. However, if you mark this box up here, D, and I'm gonna highlight it and then we're gonna zoom in on it again because I want to show you what we had talked about earlier about the Congress asking and saying all the stuff that we had to do here. I don't multitask well, sorry. So if they marked no, the medical evidence, no matter if it's the HR person, any of that stuff, whoever made this determination, in other words, whoever signs this form on the other side of this form, which would be somewhere at the bottom down under there, whoever signed this form, if they marked this box and said that the medical evidence says no, that it was not possible to accommodate them. It says right here, attach copies of all medical evidence supporting the statement and explaining why it was prohibited from being accommodated. details, the physician's note, that kind of stuff. Again, like I said earlier, this came right from Congress saying that if the agency certifies this, they must provide the information to OPM, not the applicant. Okay, there are a lot of confusing statements. We'll see people write down in the bottom, applicants responsible to send that information. They are not. This is an agency form. B and D are agency forms, and this is D. It is required that the agency fills this form out if the person is applying for disability retirement. And if they certify that they couldn't accommodate them because of the medical evidence, they're basically certifying here that they didn't do an accommodation search because there isn't one that fits their medical restrictions. The problems that are being presented by that statement is, one, that I know of, there are no HR people that have medical license from any state currently. Now, I do know that you have accommodation people. Some have a staff nurse, that kind of stuff. If that's the case, and that person is making that decision, that person needs to complete this form. That person needs to sign and date this form, and that person still needs to provide the medical evidence that they used in making that determination. Because that is coming up time and time and again at the merit board where the attorneys are arguing for or against. Understand, let's take a little side note here. Understand an attorney in any case is going to present the case in the best way possible for their client. So whatever best suits the need of their client is what they're going to say. So if this isn't filled out or isn't signed by somebody with a medical license, the attorney is going to say, well, they certified this and they're not a licensed medical practitioner. And then the judge is going to say, well, that's right. So what do we do to go about going around this? And that case, stuff like that's still pending. So we've really not gotten a very solid answer on what happens from there. But again, we're coming down to you're making a medical decision based on evidence that's submitted, and you don't really know what you're looking at. So how can you make that determination? I know that some of you understand what cold and flu is, but there are others that I'm pretty sure would not know what retinopathy of prematurity is. If anybody does, go ahead and type that in. I'll look at that and see if you're right. But there are just certain medical conditions that you're not aware of, and situations you're not aware of. They can have a federal job and come into that federal job being disabled. Up to 100%. I've seen it. I've seen people 100% service-connected, disabled, hired for a federal job, and the agency certifies here that no, the medical evidence said that they couldn't do their job. Well, what worsened? Because they came in 100% disabled, you hired them. How can you be more than 100% disabled? So then again, where does this evidence hold weight? And that's a decision that you wouldn't be able to make as an HR person, but something that I am actually trained to do as a licensed medical practitioner, as are all of the other medical specialists for the disability section. So in a case like this, you would be best just certifying that they didn't. We looked at what the supervisor said, and supervisor said that they couldn't be accommodated, or they didn't need to be accommodated. I'm sorry. Stumbling around a little bit, still trying to highlight something. And then let's go to 5, and they say that there are no vacant positions within the commuting area, and so on and so forth here. Again, this is something that has to be certified that this took place, that this actually happened. This is a reassignment effort, and I will quote you. I have the book right here in front of me, and I'll quote you from the CFR 5. The regulation is 844.103, if you're so inclined to be like me and look everything up that you're told, because I do. In section 5, part B, it says specifically, the employing agency must consider a disability applicant for reassignment to any vacant position. Great. We talked about that just a few minutes ago. But it continues on, and it says the agency must certify to the Office of Personnel Management, so must certify. In other words, you must certify and show evidence that there are no vacant positions or that it made a reasonable offer, and that the individual declined, or any of those kind of ways. So it says specifically right there, you must certify. And the only certification we take is evidence. We can't take, well, you have my word on it that this happened. I wish I could. If I could approve everybody for disability retirement too, because everybody's disabled from their job and can't do it. So again, certification, documentation, dates, all that stuff, very, 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 very important. And we can see that here as to why. So basically our common error and discrepancies here we note are the fact that the supervisor statement and the agency statement, the B on the left and the D on the right, really don't match. They really aren't talking about the same thing. As we noted in the accommodation section, the supervisor said they don't need any. They're doing their job pretty darn well. But then the agency says, well, hey, they gave us medical that says they can't do the job. Well, we've got a big contradiction here. Medical saying you can't do the job, but you're doing the job. There's a huge contradiction there, and that's where an error comes up on our end, and then we've got to go, all right, what in the world is really going on here, and where is the issue, and is there an issue, and is the medical condition really that disabling? Again, I excuse me, I harken back to our initial discussion where I talked about what being disabled would entail, and that would be, if their position is all typing and all office work, and they say they have a broken foot, well, how does a broken foot prevent you from being able to type? And again, here would be the same thing. So if we took that scenario and put it in here, the supervisor says that they don't need accommodations because they can type and they're doing all their essential duties. But then the agency is saying up here, oh, no, they can't type. We have documentation that says they can't. Well, we need that documentation because the supervisor that sees them every single day of their work day is saying they can do it. So again, in order for us to substantiate what's going on, we have to have very, very accurate and very, very up-to-date information. So that's why that's required to be sent to OPM so that we can see that. So let us go into our second scenario. We see we still have our fellow here, Mr. John Jacob Tingleheimer Schmidt, and he's still a singer, but here the supervisor is saying that there is a deficiency for performance. Okay, so here's where he entered into the position. And again, I hope these are coming through well enough that you guys can see these and that they're big enough. I tried to blow them up as best I could. But they're saying here that the deficiency started here. And then they're saying over here that there was an award of within grade step increase was awarded based on their performance. So here's where the discrepancy here comes, and I'm sure everybody has already picked this out. You're certifying that their performance is not fully successful, but you're certifying that that was starting in December of 2019, but then for the following fiscal year, their performance was so good that they got a pay raise. So does that really tell me that there's a performance deficiency if they're getting pay raises based on their performance that you're saying is deficient? So again, red flags are going up for all the medical specialists, and we're going, what in the world's going on here? And what can we do to fix this error? Who do we talk to? Do we talk to the supervisor? Do we talk to the agency? What do we do here? So let's go on a little bit and we'll remember what we saw here. Just keep that in the back of your mind. So for the performance, the supervisor said that the employee was unable to perform the essential duties of their position. Okay, that's great. Love that they certified that the performance was deficient. However, reference above, they got a step increase, that kind of stuff. And also, they didn't know what duties of their position. Now I know some positions will have 200 different roles that they can be responsible for, and you can't name them all. But there's a reason that this was certified as a performance deficiency. And what was that essential duty that they couldn't do? Did they not meet process number 4 of, such and such a guide, or things of that nature. The more detailed we can be in here, the better off we're going to be. You're already typing in there. It doesn't take you but another minute to type something else in there that's a little bit more descriptive. That definitely helps the medical specialist, us, make a better determination in this case. So again, we're going to compare here. We're going to compare that 6 with what happened up above here with this step increase, where you're saying the essential duties they're not able to do, but they obviously are because they got a performance-based award. So again, errors like this are what cause our little bit of a hesitation and something that we're going to need clarity on. Now, the next one down here for section C, this one is going to show that they do have an attendance deficiency, and it's an indefinite thing. So they're obviously not working, and they haven't been working since 2019. This is an error that I would love to correct on the form itself. And there are a lot of those that, as I have done medical disability and this particularly for OPM, stopped or became unacceptable. Well, stopped and unacceptable are 2 different things in my book. I would love to know that there was a distinction between the 2. Just because they stopped coming to work doesn't mean they're disabled. They think they are. They might have gotten a Social Security award, and they might have gotten their VA benefits awarded, but that doesn't mean that they have met the eligibility and entitlement to FERS disability or SIRS disability. So if they stopped coming, they stopped coming because they're getting other pay, and they think, well, I'm just going to get all my pay and I don't need to come to work, or it became unacceptable. In other words, they have missed 50 days out of the first 60 days of the year, kind of thing, and there's where the differences lie. So, and there too are where the differences would lie in our decision making. Stop versus unacceptable. So again, at the bottom, they said here the employee hasn't been to work since 2 of 2019. That would indicate to me that it stopped and it became unacceptable. So this is a very good example of the positive way that this can be interpreted, and it's a very good example of pretty significant documentation to support what's going on as far as this person's situation. Now we move on to the next. So now we know that there's a documented performance deficiency. There's documented attendance deficiency, and down here it says that the conduct became unacceptable as well. And they're saying that it's because they haven't been coming to work since 2019. So again, we talked earlier about whether this is actually a conduct issue or not. And it really is not. That's more of an attendance issue. And as you can see, the data of them is the same. Conduct, again, would be, like we said, throwing a laptop across the office, or, beating up a supervisor or something like that. Arrested at work. I mean, you name it, I've seen them all. That would be more of something that would be a conduct deficiency. But in any case, there is documentation here that they do have this. What I don't have in this case is I don't have the conduct. I don't have the date conduct happened. I don't have the supporting memorandum documentation. Sometimes I do, sometimes I don't. But again, if you document here, or somebody documents here, that there was a conduct deficiency, there better be evidence to support that. Otherwise, again, if we don't have evidence that's signed, dated, it never happened. So we would see that and probably pass that off as not being a deficiency. But it really doesn't matter, because they're so far, they're going to make their eligibility for a deficiency, a service deficiency, because of the attendance. What we would have to do then is determine, okay, what happened on this date, and was it a medical condition that caused the attendance deficiency, or did they just get an award of Social Security and said they didn't want to come to work anymore? So again, you can kind of see how these things go along. Now, here's another interesting thing we see, and I'm going to highlight this and then I'm going to zoom in on it, because we have discussed enough on this form that there's a performance deficiency, or one indicated, and and there are some other deficiencies. So let's zoom in here, and you'll see that on the accommodation, they say not necessary because the employee performs all the essential duties. Well, let's run back up here. And they said that they don't perform all their duties successfully. So there again, we have a huge discrepancy even within the own supervisor's documentation that just leads to such confusion that we need to figure out what's going on. There are reasonable assumptions that can be made here, and they would be just that, some reasonable assumption. We've got a performance deficiency documented. We've got a date that it became unacceptable. We've got some other things. We've got attendance. We've got conduct. We can make some assumptions that this increase that happened up here, the period increase that they got, was based on the documentation from December not being forwarded in January and not making it in time for the correct adjustment to be made. So then we could say there was an actual deficiency for performance, and that probably whatever was documented down here that we highlighted in section E is either an error by the supervisor or some oversight thereof. But again, that's just a reasonable assumption. We still have to prove that that is an actual deficiency. But again, in this case, we've got the attendance already noted. So they've already kind of got a part of the eligibility. We just have to figure out why that happened. So we then move over to from the supervisor. I know I'm going a little bit fast, and I apologize. I see some of the comments coming up above, and I'm just trying to make sure I get through the material so I can allow you guys some time to ask questions at the end. But again, remember, you can still ask questions, and Bill Deep, who is actually being played by Jody today, and she'll actually answer your questions over there, and I see she's doing so. So let's go. We have this performance deficiency that's documented over here. Okay. And we've got that they didn't need some accommodation. Okay. We go over here, and then they have done what I just said in the last part that would have been appropriate for that one, but isn't appropriate for this. They say that the condition doesn't seem to need to be to require accommodation. And that might be true if you look down at what the supervisor said. But I would then opine that if they have a performance deficiency, if they have an attendance deficiency, and they have a conduct deficiency, there's a reason for that, whether it's medical or whether it's something else. But could there be something that the agency could offer that would allow this person to be a successful employee? Is there an accommodation? Is there a reassignment? Is there something? So while I can see this being a possibility, in this scenario, it doesn't seem to fit because there is obviously an issue. And without further clarity of what's going on here, we would just be wondering, what is actually going on here, because they're saying that part of they're performing stuff well, and that it doesn't require any accommodation because medical evidence fitted to the agency says that they don't have a disabling condition, but yet their performance and so on is defunct. So in this instance as well, you can certify that no, they don't need the accommodation, but you should also do this here. The medical presented to the agency does not document a disabling condition. What evidence? If you don't supply that to us, we don't know how you're making this determination, which then doesn't allow us to make a very good determination about performance or any of that other stuff. If they've got a document, which I've seen a document come from a provider that says, no, they don't need any accommodation. Their condition's very well controlled. They're stable on their meds. There's no other issues. They don't require accommodation. So then there's another underlying reason other than a medical inability or a disabling medical condition causing the performance, the attendance, conduct issue. And therefore, as far as OPM is concerned for disability purposes, there's no reason for us to continue on because they've not fulfilled their eligibility requirement, that they show that one of these deficiencies, performance, attendance, or conduct, was caused by a disabling medical condition, because there isn't one. As long as you send the documentation that shows us what made you make that reasonable assumption. Now, again, notice here there are spaces where you can type other stuff. I hear a lot. I heard one from one of my buddies that works at one of the agencies. He said, what if we don't agree with any of these three choices? There's nothing that says you have to make one of those three choices. You can very easily type something else down in here that says, the agent or the applicant came to me and said they don't want any accommodation. Well, as you can see, there's nothing up here that says that is an option. But if you document that that's what they said, then at least that answer is in there, and it's not just something that you just picked out of thin air because you thought you only had three options. I guess what I'm getting at on that aspect is that there are other than just these three options for indication here, and in any of the categories. They all have space. You could add an extra page. Again, the more detail you provide us, the better off we can make a decision. Continuing down here to the bottom of the agency form, you see here that they say that their performance is fully successful. So according to the agency, we're getting a different picture here from the agency than we're getting from the supervisor. So over here, we've got the supervisor, and over here, we've got the agency. According to the supervisor, primarily, this guy is service deficient in every area of his job, but he can perform essential duties. I don't know. We haven't really made that determination. But according to the agency, he doesn't need anything. He doesn't need reassigned. He's a fully successful employee, and he should be working every day of his life and shouldn't be out, gallivanting around on 219 and missing work and not performing. So you can see where the discrepancy comes here, and how that causes some problems for us here in disability. And then later on down the line, when this goes up to MSPB, if it goes there, or it goes to the attorneys or the next level. So again, agencies and supervisors should know a little bit about the employee. Obviously, supervisor was probably filling out performance appraisals. And I would assume that in this instance, the agency was looking at those performance appraisals and saying, well, it doesn't look like they're having any issues. So if you see these forms and they're different, you should be asking a question, and a red flag should go up in your HR mind and say, wait a minute, these don't match. What's going on here? Maybe I should talk to the supervisor and be a little proactive and say, hey, we got this documentation that says that they're doing great. What's going on over there? And maybe there was something that wasn't submitted by the supervisor, or maybe the agency provided an accommodation that the supervisor didn't know about, which we'll see an example of here in a minute. And that allowed them to be successful, which is why they're not having any more performance deficiencies, attendance issues, or conduct issues. So again, we can just kind of see how these things kind of mirror each other, and why they're so important. And you can see why in the beginning of the presentation I talked about how I can see where the B, which is the one over on the left, provides a picture of what's going on. And then the D, which is the one on the right, kind of tells me whether what was going on was, and the efforts to fix it were reasonable, and whether they worked. So there's where those two forms kind of are meant to kind of go along with each other. And again, when they don't, then that just raises a ton of questions. So our last one here, we see this a lot. And I'm going to point this one out right from the beginning. It's our same buddy, Mr. Jingleheimer Schmidt. He does not have a performance deficiency documented here by the supervisor, but the supervisor said that his work became unacceptable and his performance became unacceptable, and put a date on that. But then also certified he got a raise. So again, is this just an error by the supervisor, or is there something that the supervisor did wrong in filling out this application? And again, without some sort of documentation, that's left up to us to try to decide, which we can't do because we don't see this guy's performance on a daily basis. And so therefore, that's why we're kind of relying on these forms to be accurately filled out by the agency. I actually argue quite often in my letters when I deny an applicant for disability benefits. I argue quite often on there that one of the attorneys likes to do this disability a doctor's opinion form, and basically what they do is they prey upon the laziness of physicians who don't want to write anything and just scribble a signature on a piece of paper and some date you can't read. So they fill out all this stuff and it says, do they have a deficiency for service in service for performance, attendance, conduct? And the doctor will check yes or no. It's like one of those little kindergarten, will you smooch me? Yes, no, maybe kind of thing. It's so generic, but they'll certify that. And I will argue all the time in my letters that doctor is not present in their work environment to know whether their performance, their attendance, or their conduct in the fulfillment of that position's duties are actually deficient because they're not there to witness it, especially when the agency certifies here, the supervisor, who does have that firsthand knowledge, certifies right here that no, they don't have a performance deficiency. But then the attorneys will come back and say, well, but they said that they were deficient on this date. They indicated a date. So any little loophole that they can stick their foothold, that they can stick their foot in to cause some reasonable doubt in the judge's mind, they'll do. And that's why I try to close those doors. Now I can argue in my letter and before the merit judge, I can argue, well, there's a familiarity. They're more the supervisor's more familiar than this doctor is, and the doctor's just basing that on reasonable medical probability for the average person of the same age, height, weight, and condition. So not necessarily true of this person, but based on the law of averages. And that seems to be holding pretty well at MSPB, that argument. But again, if this stuff right here was properly filled out, and there was nothing in this blank here, and just the two, no, there's no performance, and they got a performance raise, then there's no problem here. There's obviously no performance issue, and I don't have to go into any further. I don't have to go into any further discussion on that. Okay. So they said here, even though, let's compare here. I just highlighted box 6 for those that can see that. Box 6 asks you to identify the elements of the job they couldn't do. Well, up here they certified that they could do it. So there should be nothing in this. But you can see here they say the employee is unable to do the essential duties of their position. Again, the supervisor's own form does not match, and therefore there's a discrepancy. And I know we keep beating this over and over again, but you really don't understand how much we see this here in disability, where this stuff is just not matching up and it's just not making any sense. And again, then that causes a delay because we got to put the case on hold and develop, and it's just kind of it's a pain in the rump. So we go down here and have they stopped coming to work? Yes, they stopped coming to work and they're not coming back ever again. Is their attendance unacceptable? No, it's not unacceptable. How can you stop coming to work and your attendance not be unacceptable? I think if I stopped coming to work, I think Jody would probably call me 100 times a day, every day for a month to find out where in the heck I'm at. And if I never answered her, she would say my attendance was unacceptable. Now I don't do that, maybe 10 times, but not 100. But then again, they certify here that the employee has not been to work since 2/19. And again, I know I'm really overemphasizing this, but again, we see this day in and day out. I have probably 15 cases here at my home office with me, and I could open any one of them, and I guarantee you 13 of the 15 will have some sort of error like this in them, where it's up to me to try to dig through the evidence, see if I can find a way that I don't have to develop this out to the agency and try to certify some other way that they either do or don't have a deficiency. So again, I hate to harp on that, but that is exactly, as you see it right here, this is exactly how these come in. So then we go down to the conduct down here in D, and they certified no, that their conduct isn't unsatisfactory, but then they write in the comments, they haven't been to work since 2019. So are you telling me that they do have a conduct issue or they don't? Again, I can't make that determination based on here. But then I'll go down here and I'll look about accommodation, and they'll say it's not necessary because they perform all of their duties. So that matches with 3, but not with 6, and so on and so forth. So here I will go over here, and I'm going to highlight this, and we're going to zoom in on these two, because I told you earlier that I saw it come in, and I told you guys you wouldn't believe me, but I certify to you now, God is my witness, that I have seen this come in on an application. There was nothing filled out. It was they had their name and everything up at the top. And I don't know who did this, whether the applicant did this or whether the agency did this, whether the agency was having a bad day, the applicant was having a bad day. But there were no certifications over on the B that they'd had any kind of accommodations. But this was actually written in there. They got a new microphone, ergonomic chair, and desk. And they were offered tutoring and mentoring by Simon Cowell. And I kid you not, they wrote it in there. And then they also wrote down here, Simon said they were terrible. And I think they went on and said something else that I couldn't really put in here because it wasn't appropriate. But again, this is why things like this are why we ask that the agency fill these out and submit them to OPM. Now, you can give them to them, that's fine. But if they come right from you guys to OPM, there is a lot better chance that we're not going to get goofy stuff like this. And I have seen all kinds in here. I've seen Barney the Purple Dinosaur told me that I didn't have to have any. I mean, you name it, I have probably seen it in doing disability. So again, I know we spent a lot of time on that, and I know I overemphasized a lot on this. Didn't mean to, and I do want to get to some questions, but I want to finish through another little topic on here, and then we'll see about getting some questions and opening the floor up. We get this a lot in disability. We get people being removed for medical disability or removed for medical inability to do their job. Now, I'm going to go back and I'm going to hype on what I said again. Unless that decision has been made by a licensed medical provider of the agency, in other words, your own physician at Department of Homeland Security says this person is medically unable to do their job, or they have a fitness for duty that was done by an independent medical examiner and submitted along with that documentation, medical inability is not an appropriate action to dismiss an employee. They should be, even though unfair, they should be removed for their performance, their attendance, or their conduct. One of their deficiencies, obviously, is more so the reason that they're being removed versus medical inability. Now, it is possible that they are disabled, and it is possible that they're medically unable to do their job, but that is not necessarily an appropriate action for, John Smith of, DHS to be making. So we're really trying to get people to not do this anymore, and to find other alternatives for their removal based on, other things, conduct, performance, attendance, that kind of stuff. I mean, those are all very acceptable, and relieves the agency of making that decision. Now, I was reading a little bit earlier today. There is it's called the Federal Employment Law Training Group, and it's a company out of, I think, Texas. And they were writing about this as well, the removal for medical inability. And they said, in spite of the employee's physician determining that they could perform their duties, the human resource person concludes that based on what observations somebody has made, they are medically unable to perform the critical elements of their job. And the problem that they said with that is that the physician stated that they were unable, or they were able to do their job, but they said based on observations of the supervisor that they couldn't do their job. Where that's going to run into an error is that's going to run into an error at the merit board if it gets past me. And the error is that the merit board is going to say, well, the physician is licensed by a state medical board and the supervisor is not. So the greater weight is going to be placed on the physician based on the supervisor. So in that scenario that the people provided in their training, they actually said that they would be better off to take this way out, the medical inability, because they're almost a lock for disability retirement, and that's just not true. In this report here, they're going to be, that physician's going to be given more weight than the supervisor in that scenario, unless the supervisor can provide direct documentation of what they're claiming. So if they claim they saw Larry fall 10 times at work, and Larry's claiming, his knees give out and this kind of stuff, and the doctor says, well, he doesn't have anything wrong with his knees, but it's falling out at work, and the x-rays show this from another doctor. I mean, there are a lot of scenarios we can if then and whatever here, but basically what I want you to understand from this is removal for medical inability should be made by somebody medically licensed to make that decision. If they need removed for some reason, it should be some other reason than their medical inability, unless, like I said, a licensed physician has made that decision. And again, I'm going to reference back to what we were talking about earlier. I read to you this thing right here, which is the employing agency considering a disability applicant. So somebody that has applied for the, I think I'm getting my 15-minute warning. Sorry, guys. That's applied for that disability, they should be considered first for reassignment. So in other words, you need to exhaust every way possible, keep this person employed, and if you can't, then you got to document. Okay, somebody just joined and put a mic on. I can't see. Anyway, Bruner presumption is where we're coming at, and this will cover a lot, this right here. Just a quick backlog of this. John Bruner worked for the VA in Pittsburgh many years back, and the agency removed him for medical inability. OPM denied his disability, saying that he wasn't disabled, and then upheld on recon. And he actually, I think, went to the initial AJ, which is the administrative judge, who upheld that decision. But then he went to the circuit court judge, and the circuit judges, the panel of, said, well, the agency said that he couldn't do the job, so he has the burden of proof now shifts from Mr. Bruner to OPM and the agency to prove that he can do his job. Well, the agency doesn't have anything to say here because they removed him, saying he couldn't. So OPM had to go back and try to go through the records and prove that this guy, despite what the agency said, was able to do his job. And the medical evidence in his case actually did show that he was able to do his job. And he actually lost this case. But his case law has become precedential in that it has shown that the burden of proof, or the burden of production, as they call it, has shifted from the applicant, which is Mr. Bruner, to OPM. So if you guys remove somebody for medical inability and you don't send us any documentation whatsoever, then that applicant is basically removed of any of their responsibility to submit any evidence to us, and we've got to get the evidence and prove that they can do their job. Now, they'll still submit evidence, but I mean, that's essentially what this is saying, is the burden of production has, and that isn't fair to us because, as the disability specialist, because if you don't provide us with medical, we don't know where you're coming from on your decision. So again, even if it's you, if it's the accommodation people, whoever it might be, somebody needs to kind of let us know what's going on Okay, I don't want to harp on that too long because we've got to move along here. And this one just says it's talking about the accommodation committee, if they remove for medical inability or any of that kind of stuff. While I'm telling you you shouldn't, you're still probably going to remove people for medical inability. I get that. And if you're not licensed, you're probably going to do it and just pass it on to us anyway. And I'm cool with that. I'm just trying to help you out and say that you're helping us out more if you don't do that. But if you do, supply that medical documentation right there. Send it to us. Whatever you're using to make that decision, send it to us. Because if you don't, we're going to develop for it anyway, and we're going to bug you. And Jody is going to make me bug you. And so you can send all your complaints to Jody Jones. No, I'm just kidding. But again, we're going to develop for this stuff, and it's going to cost time, effort, money, and it's going to delay the application process for the person as well. And we're trying to get that through as quickly as we could. So just some quick points. Responsibility of the agency to complete the forms and submit them to OPM. Only healthy cases should be submitted, and we talked a little bit about what a healthy case was. Utilize the checklist that's provided. That checklist can be gotten on it's the form 3112E. It can be gotten on OPM's website. Google OPM disability forms, and it comes up. The whole packet comes up. It's really pretty easy. So use that. Those of you that have asked, email me. You'll see that here in a minute. I'll leave that up while we're doing Q&A at the end. Those of you that want to email me, and I'll send that to you. Make sure the appropriate personnel are filling out the form. So if it's a supervisor's form, it should be the supervisor, not the human resources department. And if it's the agency form, it should be the human resources department or appropriate person and not the applicant. And make sure we have a good working address for you guys. Ensure the forms, documentation, and evidence are all signed. We talked about that. Document, be accurate. Inaccuracy causes delays. And as I said, we're currently assigning cases within 3 weeks or sooner to the specialist. And we have no processing delays for packages that come into us complete. So we get them within 3 weeks. They make a decision that week. So within a month of their filing, these people can have their application approved, denied, whatever, and moving on to the next section if it doesn't come in with any of these errors. So I know I have not answered probably everybody's question. And I know that you'll have more. So here is my contact information here. And I see that there's format errors. I can also send you copies of this PowerPoint that has been approved. So I can send you copies of that so you can review some of the information. But if you have any of those requests, you can send them here to me, Robert Williams, a medical specialist at Disability. Here's my email, my extension, all that good stuff. I have people still from Jacksonville from last year that ask me questions. And I'm happy to answer them anytime I can. And I will get back to you usually if I'm working within an hour. So questions, go ahead and type whatever you have up here. We will, I will quit sharing this screen and I will, oops, maybe I won't. I don't know what I'm going to do. If you, oh, there it is. So stop sharing. And I see the questions are coming in on the side here. I will move that over to my main screen here, and I'll stay on for a little while. If you guys have questions, type them in here, and I'll see what I can do. Send them directly to me if you want to. If I can, I will, let's see. All right, I've got everybody unmuted, so do this. Oh, no, that Ray must be on again. But anyway, any questions you have, go ahead and type them and send it to everyone right to me. And I'll be on here until this thing shuts off at 3:30, I think. And for those of you that are saying, thank you, great class, I appreciate it. I hope you filled out the pre, and I don't know if there's a post, anything on there, but anything you'd like to hear further, any improvements, anything you'd like from us here at Disability. Every single one of the specialists is really, really top notch, very, very good people. really want to help out, and we do our best for both the agencies and the applicants. We want to help you the best we can.
Hey, Bob, a question was asked about the electronic signatures.
I see that there.
There was a BAL that came out. I will clarify on the BAL. I think somebody had written it down that it was BAL 20-102. And I know there was a lot of discussion that went on with that BAL due to COVID. And I believe disability packets are in that as well, but I will clarify, and I will get whether we send all the information to Kanaya and she can get it out to everybody that was in the class. I'm not sure how we're going to do that, but we'll try to get the information back out to you guys.
Yeah.
I have saved the chats, and I keep updating them as questions come in and replacing what I've got. So we will also supply those to Shania that we can see if she can get them out. The only question was how long will it take to get the process once we receive it? You're telling the applicants it's normally 6 to 12 months. That's not correct. We are doing cases with where they're being assigned within 3 weeks or sooner. The only time that it's taking longer is if they are incomplete packets, if we have to reach out for more medical and we don't get responses either from the agency or from the applicant for the information that is needed, then yes, it can take much longer for that to happen. But right now we are processing cases. I believe the date on the shelf is from July 27th. So those were the cases that were assembled and cut and put together on July 27th. And so we're moving pretty quickly with those cases. I'm not sure, somebody asked a question about going through the payroll offices. I'm not sure what your normal procedure is for your agency. And if that is your procedure, unfortunately, that's probably the way you have to go. I'm not sure on that.
I mean, our fax number and stuff, they can fax that stuff in, but at some point that'll have to be assimilated with the case once they submit their 3107, then a case jacket and everything's put together by RPS and then goes on from there. So I'm not really sure I'm not really sure how we're going to handle that. We'll have to move on with that. But the basic key there to remember with those two forms is just make sure that they're completed by the agency, and and that that was completed by the agency. Because if we call you and you say, well, I didn't fill that out, then we're going to wonder, is it fake? Is it false? Are these people trying to falsify documents? And just does that have any bearing on disability? A little bit. So.
Okay.
We'll have to see. I'm trying to read.
Yeah, I know. There's a question here about receiving OWC compensation and their disability retirements are approved. So if an applicant sends in for disability and they're on workman's comp, the applicant, if they're approved, they will be sent a letter, usually from the annuity side, once it gets to them, as to here's what you will make on disability. And then they're given an election form. Do you want to stay on OWCP or do you want to come to OPM for disability? Now, if they choose to stay on OWCP and say 3 years down the line, OWCP throws them off and says, you're done with OWCP, they can then come back to OPM and say, I was approved for disability and I want to take advantage of my disability benefits. They'll have to send in medical proving that they still have the disability for what they were approved for. And if they do that, then they can get their disability benefits. The only time that their payments are offset is if you have an employee that is approved for disability, but they're also approved for Social Security. Their payments from OPM will be offset by what they're being paid by Social Security. I hope that answers the questions.
I saw one from Melissa Coleman. And she's asking about if they refuse to work with the specialist and submit their own packet directly to OPM, even though they're still employed. With that one, there are circumstances where the agency can fill out and submit forms for the applicant in that they were incompetent to file, or they're unable to file. They don't have any other representative that could file for them. You could do things along that nature. But I see it says, I think we have an issue with this previously and received an error, but was unaware the employee submitted the application. That's another common problem, is even if they separate, the employee separates and the agency has no idea they filed for unemployment or disability.
Well, the other part of that too is I'm sure you guys have had employees that have filed for disability and they do it on their own and not through their agency.
Yeah.
If that happens and we find that, we have a gentleman that actually screens those, and if he finds that they are still on the agency rolls, 9 times out of 10, that application is sent back to the applicant and told that he has to send it through his agency, that we won't take those if they are directly submitted, if they are still on the agency rolls and still working. So hopefully that, doesn't happen too often, that it gets through that the person is still working and they've submitted the application and the agency doesn't know. If they are employed and on the agency rolls and working, they have to go through their agency. There's also a question here about reasonable accommodation for public law and dual military. They're losing their military status due to medical reasons. I don't think we even look at accommodations. Bob, correct me if I'm wrong with them, because in order for them to do their job, they have to have that military side to it. And if they can't do it, because this is an instance where diabetes could be the problem, that they're losing their military affiliation, is because they cannot do insulin while they're deployed, or there can be issues with doing insulin while they're deployed. So this is one where diabetes would probably send them out under public law, but not necessarily regular disability. I will tell you, every public NGT that comes in is still reviewed to see, do they meet our requirements for regular disability? And if they don't, and they have the waiver and so forth, then they are sat out on public law. If they have a medical condition that warrants them to receive regular disability through OPM, and the staff will approve them for that disability.
Right. And I see one here from Tamara about terminal illness. And the terminal illness cases are unique. And those tend to get a little bit more priority as far as cases go. We do stamp, or we actually put a paper on them that say, it was determined that this was a terminally ill case, because obviously we want to get them benefits as quickly as possible, especially if it's there. Now, going back to what I said about healthy cases, they still have to submit a healthy case. If they just put in a 3107, which is their application for immediate retirement, saying they want disability, and one form and no medical, then we're going to have to develop, and we're going to have to go through that process, and it's going to take forever. But if you as an agency have a person or a family member or so on that comes to you and says, my husband hasn't been to work, he's terminally ill, call myself or email me or say, Bob, I got this going on. What do you need to get this case started? And I'll help you through that. But the basics are, as quickly as you possibly can, get a healthy case together and get that submitted into OPM, and make sure that there is some specific information on there that identifies that as a terminal illness, or what you believe is a terminal illness. And I say that because we get them all the time, where somebody says, they're terminally ill, or and they stamp on there because they have cancer. Well, it turns out that they were in remission 8 years ago. And so, and now they're suffering from what they think are some side effects, but they're not terminally ill. They were at one point, but they aren't anymore. But again, I guess my best advice there for you on that one Tamara, is to just get us that case as quickly as possible and as healthy as you can possibly get that case to us, and let us know it's coming. Email me. My email was on there. Just send me an email and say, I have this case coming, and I'll look for it.
Also, I know a lot of you, or quite a few of you, have my email address and my phone number. I do get emails, and I do get your records that you send, actually, the whole case to me in an email stating that it's a terminal case, and that's fine. We get the ball rolling on that, but the case still has to come through the system the way that it's supposed to, and it's nice to get that heads up that, hey, this is coming. If I get an email from you guys that states, hey, this case is coming, it's a terminal case, I let our retirement prep section know. And the lady down there that's in charge of that section actually puts a flag out for it. And as soon as it comes, she gets the case cut, gets it up to me, and then we get it assigned and decided. So some of these cases, we've literally gotten out probably within a week, if not sooner, if we know that the terminal cases are coming. So my email address wasn't on the slide with Bob's, but I can give it to everybody if you want to write it down, and I can also put it in the chat for you. But it's Jodie, JODIE .Jones @opm.gov.
There was another good one that just came up, and it came from Mr. Young, and it's about disability based on mental illness. And that one really, those are really, really hard to prove from a disability standpoint, especially if they're pre-existing medical conditions, like, they're saying it service connected because they were a combat vet or something along those lines. The best case for that is if they've had a psych eval or a fitness for duty or any kind of specialized testing like that they can provide, is better than just a mental health note from the VA that says, I saw Joe today and, he was fidgeting with his fingers, but he was cooperative and, that kind of stuff. So for me in particular, I'm a combat vet as well. So I get it. I have a heart, I have a family, I have a beautiful wife, beautiful granddaughter, great kids. And I understand if I had a huge exacerbation of those symptoms, how that could play a role in family dynamics. But I've got to have, if I'm going to file for disability, I've got to have something more than just a psychiatrist or a licensed social worker. I get those all the time too. That says, well, they meet the DSM-5 criteria. That's great. I could go to a psychiatrist right now and convince them that I meet the DSM-5 criteria for PTSD, but I don't have it. I don't have any ill effects from it, but it's so subjective that there has got to be some more specialized testing provided that can help us substantiate what's going on there. So in your case, Mr. Young, that's the best information I can give you is the more documentation they can provide that's of a specialized nature, the better off that application will be coming to us, and the better we'll be able to approve that. I hope that answered your question.
Hey, Bob, there's a question here about the 3112A. Do we have, they have the information, they get, maybe I'm not reading this right. Agency receives a letter for the 3112B. The B specifically says for the supervisor to complete documentation after receiving a completed A. We do not have this information. If we do have the A, can we forward it to the supervisor since there is medical documentation and we do not have authorization to share this information? It's HIPAA protected.
Yeah, HIPAA protection, you can discuss that amongst parties that are involved. So supervisors involved in the claim, they're certainly privy to that information. So there's no violation of HIPAA there. But I didn't know that said that they had to have the A to do that. If you read the B, regardless of that section that says that, if you read that B, it's pretty clear that you just have to document whether they're doing their job, and if they applied to you for accommodation, because they should, their first line should be coming to the supervisor and saying, hey, you know, I'm having some issues and I need some reasonable accommodation, which is every employee's right. I could go to Jody today and ask for reasonable accommodation. I don't have to specify why to her, but she would provide me with the forms and so on to do that. So I'm not sure if that answers your question or not, but if it doesn't, give me a little bit more specifics in an email, and then I can see if I can try to get you some better reference there. Let's see. I see if an employee was removed from the agency and files disability to OPM, what do we do on the forms that they're asking for that should be filled out by the employee? Do I write removed in the date of the form? Yeah, if that's beyond their removal date, you could put that on there that they have been removed, but we should already have that information. Basically, we wanted to find out what they were doing while they were in service. So that's the kind of information that we're putting on there. What were they like during their service? Because their obligation for fulfilling their burden of proof is that they have to prove that they had a service. And so they can say they had one, but the agency is who certifies what goes on there. So you would still have to certify that there was something going on, but you can also put on there they were removed. I hope that answers your question, Thea. I'm sorry. There's a lot coming through.
This last day of pay question, that I'm not sure of, because that is money's side and we don't deal with that side. So I'm not sure about the lump sum payments and if they can do anything about that or not. Again, I'm going to save the chat, and these questions that we're unsure of, I could check to see if we can get some answers for you from the division that does the money side of it, or the annuitant, calculations and so forth, but I'm not sure.
Yeah, we do a little bit with we know a little bit of the back information on the pay, but not much. That's really kind of a weird formula, and math was never really my good subject, unless it was the metric system. I seem to get that better than I did algebra, but yeah, we'll definitely reach out. We have a couple contacts there that we can find that information out, and so we'll definitely get back to you on that one. I guess that's probably going to be it for now. We probably shouldn't keep everybody any longer than we have to. For those of you that participated, thank you very, very much for showing up. And again, I hope you wrote down that information for us. If not, look us up. And give us any questions you have. Email me, problems, complaints, comments, concerns. We are always here to help you guys. And anything that we can do to make your lives easier, we will certainly do, and hope that you can do the same for us. I hope everybody stays safe, healthy, and has a wonderful day. And again, any questions, email or call us, and stay safe.